Customs legislation and regulations. Generalities. The sources of customs law. Customs authority must take into account the principles of international law, to which their states have acceded. Customs law includes all the legal and regulatory provisions governing the various fields of intervention of the customs. These provisions consist of several acts. First, the international acts, international agreements, arrangements, treaties or conventions to which the country accedes shall apply, as soon as they are notified to the customs authority. Under the national customs codes, the customs provisions for which it is stipulated in the agreements, arrangements, conventions and treaties, that they enter into force upon signature of the said acts shall be applicable upon notification to the customs authority. Among the international sources of inspiration for customs law, it is worth mentioning in particular, 1. Conventions issued or managed by the World Customs Organization (WCO). Today, the World Customs Organization is the ideal framework for the exercise of customs professions. Under the auspices of this international organization specializing in customs matters, several conventions have been concluded or managed with a view to simplifying and harmonizing customs practices and procedures, adopting a common language with a view to promoting the flow of international trade, and providing mutual assistance between customs authority to prevent, investigate and punish customs offenses. 2. The International Convention on the Simplification and Harmonization of Customs Procedures, known as the Kyoto Convention 1973, revised in June 1999, and entered into force in February 2006. The International Convention on Mutual Administrative Assistance to Prevent, Investigate and Punish Customs Offenses, Nairobi Convention 1977. The International Convention on the Harmonized Commodity Description and Coding System and its annexes, done at Brussels on 1983. The Customs Convention on the Audit Carnet for the Temporary Import of Goods, signed in Brussels in 1961. The following are also conventional sources of customs law, agreements resulting from the World Trade Organization, and also all agreements resulting from this organization that have implemented its commitments, including the consolidation of the customs tariff, the application of the customs value agreements, the anti-dumping and safeguard measures, the trade and tariff, association and free trade agreements binding the country to other trading partners. All these agreements have implications for customs legislation insofar as they derogate from the most favored nation principle, and also provide for the harmonization of the customs laws of the contracting parties. Among these agreements, it is worth mentioning in particular, trade and tariff agreements binding the country to certain countries, association agreements concluded with the member states of the European Community, free trade agreements concluded with the countries of the European Free Trade Association (EFTA), the Free Trade Area Agreement signed between the countries and the USA. Other conventions containing specific customs provisions are also worth mentioning, in particular those relating to international transport, the environment and security. As an example, the Customs Convention on the International Transport of Goods under cover of a TIR Carnet, the Convention on International Trade in Endangered Species of Wild Fauna and Flora sites, signed in Washington on March 1973, the Convention on the Transboundary Control of Hazardous Wastes and Their Disposal, known as the Basel Convention, in force since May 1992. Of course, there are other agreements and conventions on which customs legislation is based, but our aim is to mention only a few conventional international sources of customs law. Second, the national acts. These are the legislative and regulatory sources of customs law. In this respect, a distinction must be made between purely customs legislative and regulatory sources and non-customs sources applied by customs in the context of assistance to other services. The national acts of a legislative nature. With regard to purely customs legislative sources, it is worth mentioning the customs code approved by the national political authorities. The import duty tariff, as fixed by the Finance Act and including the positions and subheadings of the nomenclature resulting from the International Convention on the Harmonized Commodity Description and Coding System (HS). With regard to non-customs legislative sources containing certain provisions of interest to customs, it is worth mentioning in particular the laws relating to trade, or, alternatively, the provisions of the law on the protection of industrial property, empower, under specific conditions, the customs authority to proceed at the borders, to suspend the release into free circulation of goods suspected of being counterfeit or counterfeits. In addition, the customs action is carried out for the application of the provisions in the context of the assistance it provides to other services, that is in the collection of duties and taxes, a contribution to consumer protection. As such, it applies quality control provisions, technical standards, sanitary and phytosanitary measures, veterinary measures, fraud control, border measures, etc. Part 1. Basics and legal basis for the customs authorities' action. Through this part, we will successively focus on the definition of certain basic customs concepts, the legal basis for the action of the customs authority, rights, obligations and powers of customs officers. The fundamentals. 1. The customs territory. The customs territory is defined as the national territory including territorial waters. By national territory is meant the geographical portion of the planet on which the full and complete sovereignty of the country is exercised: continental land, islands, maritime waters, airspace above the said territory. 2. The subject territory, the taxable territory, the land part of the customs territory. The National Customs Codes extends this definition to ports, harbors, offshore platforms, dredges and similar equipment circulating or operating in territorial waters and all other installations located in territorial waters defined by decree, excluding free zones. Free zones established in the customs territory shall be exempt from all or part of the customs laws and regulations. 3. Importing. The import of goods means the entry into the taxable territory of goods from abroad or from free zones. Under customs law, the import operation only takes place when the goods cross the first point of the taxable territory. In the case of land transport, the import is carried out at the moment the means of transport arrives at the first customs office. 4. Exporting. Export is defined as the exit of goods from the taxable territory. 5. The release for consumption. The customs regime that allows imported goods to remain permanently in the taxable territory. This regime involves the payment of any duties and taxes due and the completion of all necessary customs formalities. 6. The goods. Under the various national customs codes, goods are defined as products, objects, animals and materials of all kinds, prohibited or not, including narcotic drugs and psychotropic substances, whether or not they are in illicit trade. 7. Prohibition. For the purposes of applying customs legislation, prohibition shall mean all goods the import or export of which it is prohibited for any reason whatsoever, or is subject to restrictions, quality or packaging rules or special formalities. However, the production of a regular title such as an authorization, license, certificate authorizing the import or export and applicable to the declared merchandise, compliance with the rules restricting imports or exports in terms of quality, or packaging rules or the completion of the said special formalities, shall remove the prohibition and allow the import and export operation to be carried out. The scope of the customs authority. The action of the customs authority shall be carried out throughout the customs territory under the conditions laid down by the legislation in force. 1. The customs action radius. The customs radius is an organized surveillance zone along land and sea borders, and includes a maritime zone and a land zone. A. The maritime zone of the customs radius corresponds to the territorial waters of the country as well as the contiguous zone. B. The land area of the customs radius extends, c. on the maritime borders, between the coast and a line drawn 20 km below the seashore. d. on land borders, between the border of the customs territory and a line 20 km below it. Distances are calculated as the crow flies. Roads, railways and watercourses, as well as all parts of a locality crossed by the line, are included in the land area of the customs radius. 2. The customs police action. The interest of this action lies in the application of specific legislation and regulations to this special surveillance zone. This is called the police department of the customs authority. It is the set of rules and measures taken by customs to control the movement and storage of goods, so that it is possible at any time to establish their origin. Are also subject to the police action. Livestock. Products subject to domestic consumption taxes. Products prohibited for any reason whatsoever, or whose entry or exit is subject to restrictions, with the exception of industrial products subject to the control of Industrial Protection Quality Standards. These goods may only move within the land area of the customs radius under cover of a special pass issued either by the customs authority or by local authorities in localities within the radius, where the customs authority is not represented. Customs offices and posts. Customs formalities can only be completed at customs offices. They may also be carried out by decision of the Director of Customs Authority or the person authorized by him for that purpose, at the business premises of importers or at the places designated by that decision. Customs offices and posts are created by government decree, which also sets out their powers. They are deleted in the same forms. The abilities, obligations and powers of customs officials. In view of customs legislation, the customs authority has general powers of action throughout the customs territory. 1. Abilities of customs officers. Customs officers are under the protection of the law. It is prohibited for any person to oppose the performance of their duties. Civil or military authorities and law enforcement officials are required at first request to assist customs officials in the performance of their duties. Throughout the customs territory and in all cases where the officials of the customs may lawfully carry out their duties, they shall be entitled to wear a regulatory uniform provided by the customs authority under the conditions determined by regulation. Similarly, all public officials have, for the performance of their duties, the right to carry a regulatory weapon provided by the customs authority under the conditions determined by law. They are also authorized to use appropriate machinery and means, such as barriers, harrows, hedgehogs and cables to secure the means of transport, when the drivers do not stop at their summons. In addition, they may, for the exercise of visiting rights, audits, controls and surveillance, use regulatory seals too. Obligations of customs officers. Customs officers called upon to issue a ticket shall be provided with an employment commission, which they shall submit upon request. They shall be required to take an oath in the forms and under the conditions provided for in the regulations relating to the oath of the ticketing officers. Any agent of the customs authority, who is dismissed from his employment, or who leaves it for any reason whatsoever, shall immediately hand over to that authority his employment commission, the registers, seals, weapons, effects and objects of equipment for which he was responsible for his service, and shall render his accounts. He must also return to the authority all the distinctive signs of the uniform in his possession. 3. The powers of customs officers. For the application of the provisions of the customs laws, customs officers' powers are granted to exercise main control functions. 1. The visit of the goods. Customs officers carry out the physical examination of import and export goods, and have the right to control goods subject to proof of origin within the taxable territory and goods designated by law circulating within the customs radius. 2. The visit of the means of transport. Within the maritime area of the radius, authority officers may board and visit any ship of less than 100 net tonnage. In order to effectively combat the attempt at fraudulent payments on the coast by small vessels, customs officers shall have the right to go on board vessels in the maritime area of the customs radius, and to be presented with documents attesting to the tonnage of such vessels. Similarly, they may also request the original of the manifest they are referring to neither and of which they are given a copy. The customs laws allows government officials to prosecute, even on the high seas, ships that have not complied with their summons, and are not arrested at their orders, and to use all appropriate means to have the ships arrested. Customs officers may also board any vessel in ports, harbors or rivers and remain there, if they deem it necessary, until their unloading or departure. They may request the opening of hatches, rooms and cabinets, as well as the packages they designate for the visit. Customs officers have the right to ask the holders or carriers of goods liable to duties and taxes to produce any document certifying that these goods have been duly introduced into the taxable territory. 3. Checking the identity of persons. Customs officials may require knowledge of the identity of persons entering or leaving the customs territory, or circulating in the customs radius. To do so, they may require the presentation of an identity document. Where there are strong indications that a person is carrying narcotic substances concealed in his or her body, customs officers may subject him or her to medical screening examinations, after having obtained his or her prior express consent. In the event of refusal, a request for authorization is submitted to the judicial authorities of the jurisdiction, which may authorize customs officers to conduct medical examinations. He then appoints the doctor in charge of practicing them as soon as possible. The results of the examination communicated by the doctor, the observations of the person concerned and the progress of the procedure must be recorded in a report. 4. The ability to search and visit homes and premises for professional use. Where there are serious indications that fraud may have been committed, customs officers may, with authorization, carry out searches and visits of homes and business premises in order to search for the goods submitted anywhere in the customs territory. To the department police throughout the land area of the customs department, searches and visits of homes and business premises are subject to the general rules laid down in the Customs Code. 5. The ability of communication. The right of communication is the prerogative that allows customs officers to require natural or legal persons to communicate all documents relevant to their mission in order to take note of them and, if necessary, to seize them as evidence. Refusal of communication constitutes an infringement of customs legislation, which may give rise to the application of periodic penalty payments provided for in the customs laws. Customs control of postal consignments. The customs laws also allows customs officers access to post offices with regard to postal consignments, in order to carry out the necessary controls under the legal and regulatory conditions in force.